All right, hello everybody. Here we are. Travis and I are here today. We're going to be talking a little bit about the pardon the pardon request filed by Brendan's lawyers. I have my own YouTube on. Hold on, silly me. There we go. So we're going to be talking about obviously the request for the pardon that was made, and we're going to be going through the request here a little bit today, and that's what we're going to be talking about. We're just to mention also, we'll try to mention this at the end as well, but there's a little research project going on that we're doing regarding the appeal. It's regarding the video we're putting together, and we're trying to find and locate and gather together certain documents. So anybody who's interested in being part of that, go over to the Legal Corner in Discord, check that out. So today we're here to talk, like I said, about, we know it's been denied. We've all heard the denial, but we're going to look at the actual request here today. Travis has kind of gone through it, and he just thought there was a few things he'd like to point out, and that's what we're going to be doing here today. So, hey, Travis, how you doing, buddy?
I'm good. Hello, everybody. Happy New Year a day early.
Yeah, almost. Happy almost New Year. Happy New Year's Eve. That's not even New Year. Anyway. New Year's Eve. Anyway. So obviously, we're all pretty stunned by the fact that the denial came through. And I don't know, I was going to ask you what you thought about this, Travis, but I was wondering in the way that it was worded, and when it's clearly petitioning the governor himself, and the way it came back worded like as if it was from the parole board, is that maybe some kind of political maneuver, maybe where Tony Evers is leaving the door to potentially go and grant this maybe 3.5 years from now or something, maybe perhaps, or in 7.5 years or something, when he's getting ready to leave office? Or whatever it might be. Yeah, is he leaving that door open?
Yeah, that's two questions. Running the decision through the parole board rather than directly from his office was a political cop-out, political evasion, avoidance, that for whatever reason he wasn't ready today. But the door is definitely wide open for Brendan to file another petition. It's gonna, the timing on it will be critical. There's gonna have to be some behind the scenes discussions. They're gonna have to find out, what his hesitancy was, what he needs, to get over this, whatever barriers he perceives to granting it.
Right.
Why I wanted to go over it, even though, the decision's been entered. The decision was a form letter. It's a form letter that, they created the board. Mm-hmm. When Governor Evers was elected, his predecessor Walker said, he didn't even convene a parole board. Right. But I'm not going to consider any applications for pardon, clemency, anything. That's the judicial, that's a judiciary function. I'm not going to invade that. Never heard of a governor taking that radical of a position before. But in any event, Evers, after he won, he put the board in. Some people were a little critical about how long that took, but he instituted the board, and then they kind of set parameters on what they were going to be, hopefully just, initially looking at. But initially they were looking at, if you'd gone to prison, served your prison time,
yeah,
you could apply for a pardon to restore some or all of your
rights. Yeah,
your rights. So right to vote, maybe the right to hunt, fish, I don't know, own a firearm, whatever it was.
I know one guy who he'd gotten into a bar brawl when he was like 20 or whatever, and he was now something like 32. He'd done his sentence. He'd been out for over 5 years, but he wanted to get it all pardoned because he actually wanted to go into law enforcement. You know, he just made a dumb decision when he was a kid, but that's really, you know, he was really pretty much a straight-laced guy and wanted to go into law enforcement. So I thought that was interesting, and he was granted his pardon. I remember that was one of the pardons.
Great, because there should be that system. In most states, that's a totally separate system. We call it expungement in Texas, or motion for non-disclosure. We call it sealing in some states, sealing of records. But
right,
should be a completely different process than what we typically consider pardon or parole,
right,
or clemency, or pardon, clemency, commutation. Those all have significance to their terms, but so what my understanding, when they said they were filing it, and what they were asking for is that they weren't even filing it with the board, that they were filing it directly with the governor. And I see,
right,
after reading the petition for the first time today, that I was incorrect in that assumption. They filed it through the board, but they asked that the board waive certain provisions, and in the alternative, they asked that the governor just go ahead and grant clemency, which he can do without it going through the board at all. He's got the constitutional power to commute any sentence under their constitution, but we'll go through that. But the other thing, I wanted to talk about this tonight with you is, in reading through it, I've only had a chance to go through it once, but they did an excellent job. And I put the link that anybody can download it and read it for themselves. It's not terribly long, 30 or so pages maybe, broken down. It's in very simple language. You don't need to read the footnotes if you don't want to, although there's a lot of good background material in there. But you just read through this thing and you see what an awesome job this team of lawyers did. I wanted to make everybody aware of what a fantastic job they did. And it certainly wasn't for lack of effort and excellence in the preparation of the brief, not in the least. This all sits with the governor. The buck's going to have to stop with him. And hope you heard their response when they heard it was denied right before Christmas. They said that they were going to proceed forward and still be pounding at the governor's door. So that's paraphrasing. They worded it much more eloquently than I did. But so you've got the petition up there, and I've just made some highlights, and we'll go through this initial part pretty quickly. But what I wanted to highlight here on the first page is that it's filed with the Wisconsin Parole Board, and let me pull that up on my Wisconsin Pardon Advisory Board.
Right.
Filed on October 2nd, 2019.
Correct.
And then below that, we've got the familiar names of Erekose right at the top.
Mm-hmm.
But we also see that Seth Waxman from Washington, D.C., the former Solicitor General of the United States, he's still on board. He's put his name on the petition. He's the one that handled all of the key aspects of filing the writ for cert to get the case heard in the U.S. Supreme Court, which unfortunately they declined to do. And I think he was also instrumental in getting all of those amici on board to file the four amicus brief. And then Robert Dvorak is the local Wisconsin counsel, and I'm sure a lot of your folks will remember him. I sent you a photo of him. He was in episode 10 of Making a Murderer 1 with Laura and Steve at the evidentiary hearing. And I think you said you recalled he's the one that you saw him in
He's the one that went and tracked down O'Kelly.
Yeah.
And dragged O'Kelly by his ear back to Wisconsin with his videotapes and his paperwork and his notes of everything that went on with Brendan.
Yeah.
And everything. So yeah, it was Robert Dvorak was the one that went and dragged that guy back and made all that stuff part of the record now for us to know what the hell happened with Brendan while he was in custody. Because otherwise we would all still be wondering what the hell happened. So
yeah, and so it's hard for me to watch the commentary and questions and whatnot coming in as we go through it. But as we go through this petition, I think I'm going to be able to point out in the petition that this didn't get denied simply because it didn't meet the requirements of the pardon board. They also did alternate grounds for a commutation, which doesn't require it to even be submitted to the pardon board. And that's the point I kept stressing, and we'll see later on. They cite 36 other cases involving murder, attempted murder, and manslaughter. 36 previous cases in Wisconsin.
right.
In Wisconsin, where they granted a petition for commutation. So, and that wasn't through any board, just governor. It finally got to the governor's desk. It got to a governor who was receptive and willing to have an open mind and consider everything, and they did it.
Right.
They reference an exhibit, and we're going to try and get that exhibit directly from Stephen and or Laura before the end of the week, and then we can specify those cases. I've never run across anything that where they've been inaccurate in something that they've cited. But okay, so let's dig into this. Did you want to say anything before we start getting into the substance?
Just no, not really. Just it's interesting, obviously, that Seth Waxman is on board. I think that's an interesting thing to note. Brendan couldn't ask for probably better representation than Seth Waxman. He's already scored some W's in terms of SCOTUS. He's been in there and he's won some cases. So honestly, I got to say that's a good thing, and it's good his name is still appearing on the paperwork and that he's still involved. So I'm glad to see that. But other than that, let's move forward.
Okay, so page 3, which you have up there now, I just highlighted a couple of things. This is the introduction part of it. And their introduction, they're saying these 3 convictions that Brendan got for first-degree intentional homicide, the sexual assault, mutilation of a corpse, are convictions that the board can have no confidence. And you'll keep seeing that term over and over again as we go through this, no confidence.
Right.
Then
is that their way of basically making this about actual innocence?
That's right. That's right. They went for the whole enchilada as their first choice, but then their second choice was a commutation, and that's going to be at the very end.
Right.
But that sets it up to at least allow the governor to consider actual innocence.
Right.
Then below that, I have that they get right into that the confession, so-called, is marked by Brendan's utter inability to describe accurately the method by which Ms. Hallbach had been killed,
right,
until he was told by police that she had been shot in the head.
Right.
She goes on to quote Judge Williams of the Seventh Circuit, and it's that famous line I think you've mentioned several times in listening to you,
Right.
Erekose. The continued incarceration of Brendan Dassney represents a, quote, profound miscarriage of justice, period, end quote. Then they
another one was the majority judge's decision will leave this tragedy, I believe, something like that, unredressed. That was another powerful wording for me.
And I actually highlighted that later on.
Yeah.
So yeah, I think that's a big one for this legal team, Laura and Stephen, also.
Right.
It says board can also have no confidence in the trial process. We'll get to that. But specifically, they're quick to point out what led to a great deal of this, a significant amount of the problems that Brendan faced at trial.
Right.
They say is documented in emails and on videotape. Kaczynski pressured his client into pleading guilty by hiring a private investigator to coerce Brendan into making another, even more nonsensical statement.
Right.
Even the Wisconsin Solicitor General's office, this is in connection with the federal habeas appeal, refused to defend the substance of Kaczynski's conduct on appeal.
Right.
And we'd gone over that real quickly in the past, but I wanted to emphasize that that's a big thing. They didn't fight it trying to say, oh, that wasn't ineffective assistance of counsel. They just basically said, we're not going to address
We're not going to defend it.
Yeah.
No, that's the way Luke Berg, I remember. Oh, I can hear it in my head right now.
Yeah.
We're not going to we've never defended Lane Kaczynski's actions. We have never ever, his actions were indefensible. These are the words Luke Berg used. So yes, I know what they mean.
Yeah. Yeah. Exactly. So, and that's a big thing. Happens occasionally, but it's very, very rare. If you skip down to the next page, they talk about Brendan's pristine and, quote, exceedingly benign, unquote, prison record that Judge Duffin commented on that caused him to conclude that
Brendan posed no danger, right?
Could be immediately released.
Yeah.
He's supported by a strong network and personally committed to a productive and peaceful life. Brendan is poised for success.
I believe that's true.
Yeah. Seeking clemency from the governor is now one of the last remaining legal options available to him. And I think that is probably true. As I am going through all of the trial stuff in Brendan's case, which I hadn't gone through in nearly as much detail as I have Stephen's case, but it's just the legal logistics, the evidence in Brendan's trial. It's completely different.
Right.
He does have a 974-06 post-conviction motion available to him, just like Stephen is going through now.
Right.
But the cases are so radically different that the same things don't apply. Someone asked the other day, I think it was Julie, well, if they violated the evidence preservation statute, doesn't that apply to Brendan? And yeah, it does. The statute applies to Brendan as much as it does Stephen. They would be required to notify him or his attorneys before they destroy any biological evidence that's covered under the preservation statute.
Well,
but go ahead.
Well, I guess, yeah.
So here's the thing. So
they'd have to actually prove that those bones were for somewhere else so that they could prove that the burn happened somewhere else. Then that would effectively be another hole in Brendan's confession, right? That would essentially be what he would kind of need to happen from that, right?
Well,
for it to effectively help him. I mean,
but if you see how his trial went, the lawyers didn't contest a lot of information. It was by like mutual agreement, you could tell. And so a lot of that evidence, it wasn't contested. Now, there are some things that might be able to be established through some sort of testing if that have been destroyed, that could be of help to Brendan, but it's so iffy what the court is going to grant in Stephen's case in terms of an evidentiary hearing. It's just impossible to predict, but there are some things that could be of benefit to him that come out of Stephen's post-conviction proceedings or additional testing that Stephen may be able to do. However, it's not an automatic, and logic would tell you it's an automatic. You got two defendants charged with the same crimes.
Right.
Stephen's case, they dropped the sexual assault case at the end of the case, had to, because Brendan recanted his confession. They couldn't use that anymore. So they convicted Stephen of murder and acquitted him on mutilation of a corpse. Brendan, they convicted of all three charges, but same incident, same transaction or occurrence. And you would think, well, one thing that's good for Stephen over here would be good for Brendan over here. But it doesn't work that way because, as they point out in this petition, the primary thing that got Brendan convicted was his confession. In fact, that is about all that got him convicted. And they point that out in here. Whereas Stephen was convicted with, scientific testing and the circumstantial case. And then because of what his contention is and Zellner's is, and what his trial attorney's contention was, planted evidence. And Brendan didn't go that way. He just said, hey, look, I made a false confession, and, this is why kids like me falsely confess, and I take that back. And if you discount that, if you discredit my confession, there's nothing that links me to the crime. But
right.
So that's why they are different.
Yeah. It's different things that the convictions hang on, and I get that. So, but I figure if you continue to shoot holes in the confession he gave, I mean, the thing's seems to me by now the thing's wobbling and on its last leg as it is. After everything it's been through, it's only just barely standing, in my opinion, by a chance.
I think from a public eye point of view, I don't think it has any standing at all. I think from a national prosecutor point of view, it's no good. I think from a national law organization point of view, it's no good. Exactly, what those amicus briefs, on behalf of prosecutors and law enforcement, so on and so forth. And we'll see, it has no legs any longer within those circles, which are important circles. However, unfortunately, it is legally, it is a valid, uncoerced confession, and that is never going to change.
Right. Well, currently, yes, it's rubber stamped by the courts, and that's where it is right now. But like I said, that's for me a kind of a chance happening due to the on-bank review, or so I don't know, but that's that's the way I see it.
Right.
But.
Well, and so that's why we're seeing that they've made this major push with the pardon board / Governor Evers,
Right.
because he is one of the last remaining legal options available to him, and that's wise because the district court, the magistrate of the district court, granted his writ. It got affirmed with the 3-judge panel in the Seventh Circuit, and unfortunately got overturned in an en banc review 4-3, and then they appealed that to SCOTUS, and they declined to grant cert, so it wasn't reviewed, unfortunately.
Right.
So that's where we're at. It's there's legally there's nothing that can be done at this point to go in and
to do anything about the confession or the validity of it. It's been argued.
Yes, unfortunately. So then they start to go through the procedural history, and people are interested, they can go through that, but there's a good summary of what happened procedurally, and that takes us over to page 5. And one of the things I noted is that they had an initial evidentiary hearing January 2010. They filed a post-conviction petition on the grounds of ineffective assistance of counsel, and requested a new trial. That was denied by Judge Fox, and then appealed up to the Court of Appeals. Right. And then that was also appealed to the Wisconsin Supreme Court, but they denied to hear it. That's what we call discretionary review. So they wouldn't even hear the case.
Right.
Then down below, Brendan has no pending court proceedings at this time. As of the date of this petition, he's 29 years old and has served approximately 13 years in prison. And again, this was as of October of this year. Right. So that's pretty sad. Anyway, so basis for granting clemency, they are going to state 4 grounds. The first is the board can have no confidence in the evidence against Brendan Dassey.
No confidence.
No confidence. Going down page 6, he will be first eligible for parole on November 1, 2048, when he will be 59.
Yeah.
So they're obviously pointing this out about how harsh this is. The crime scenes contained none of the evidence, none of the material collected from the crime scene connected 16-year-old Brendan to Ms. Hallbach's disappearance in any way.
Right.
A striking absence of expected evidence that is all too common in false confession cases.
Yeah.
Then they jump into, as an initial matter, Brendan was and is precisely the kind of person whom well-accepted psychological research has identified as particularly likely to falsely confess, even when subjected to standard police interrogation tactics.
Well,
so that's what you were.
Yeah, and Reed warns us itself. Reed says, "Do not apply this to a mentally or somewhat disabled or in whatever way, but you're not supposed to use it on juveniles, especially ones who might have some limitations." I mean, Reed tells you that itself. It's just that officers ignore it.
Yeah, so they're pointing this all out for the governor to make sure he understands what's at play here. Then in the
Yeah.
footnotes, they cite the Inglewood 4 case. That's a very famous false confession case. 4 teenagers convicted of rape and murder. And then they were convicted, even though the DNA evidence at trial, none of it matched any of them. But of course, the state, because they got the confessions, they're like, oh well, it's they probably got the lab techs to give up there and said, well, you don't always leave DNA in a sexual assault, which is true, but 4 of them not leaving any,
right, yeah.
Whatever, they came up with something. I have to go back and see what the race, nationality of those 4 teenagers were. I bet I could guess. Anyway, page 7, they talk about the Brendan's testing and his what I call cognitive deficits, but I like the way they go through this. They go into specifics about where he's below average, and it's not just intelligence, but Brendan's overall impairment level was in the most severe range, and that at 16 he was functioning like a much younger child. Test results range from 5 years, 8 months to 11 years, 9 months. His total language score placed him at the first percentile. That's the bottom 1%, folks, meaning 99% of kids his age understood and used language better than he did.
Right.
Talk more on that. Let's see. Then I found it interesting at the bottom of page 7, they quote Ken Kratz's book. And I'm like, why in the heck would they do that? And later on, we'll see more. I thought it was maybe just to get a dig at Ken, because Ken referred to him, Brendan, as a psychopath, mentally ill, or accomplished liar. That shows how stupid that was. He doesn't have a mental illness. He's never been diagnosed with any mental illness. Doesn't exhibit anything close to being a psychopath. And to be an accomplished liar, you can't be in the 1 percentile in speech language disabilities.
Right.
So then the next page, it's that quote by, so this is a case that was, that Steve Drizzen was involved heavily in, State versus Gerald. And you've heard about, you've heard me talk about this case before, Erekose. This is the case that the Wisconsin Supreme Court, specifically Chief Judge Shirley Abramson, who's now retired, I think she has cancer. But anyway, she retired, and it triggered that election. But back in 2005, she came up with this decision and said, we've been waiting on the legislature to pass a law that you have to record juvenile confessions, and we've waited long enough. We're just going to require it. And the legislature can either pass something or not, but we're not going to have this anymore. And then you just think about that for a minute. She said, we've been asking the legislature to do something on recording and videotaping of juvenile confessions, and we're just tired of waiting on it. And Steve was involved heavily in that case, and this is what Justice Abramson said. Although it's difficult for many of us to understand what leads an innocent person to confess to a crime, especially a serious felony, researchers have documented that false confessions are a leading cause of wrongful convictions of the innocent in America. When used against vulnerable suspects, Standard police interrogation techniques are especially apt to lead to false confessions. Juveniles and the mentally retarded, I think the term mentally retarded may have had a different meaning back when she wrote.
Yeah.
I think.
Or it didn't have quite the stigma then, and she felt
Yeah.
comfortable using it.
Right. Are the most vulnerable to modern psychological interrogation techniques. It follows that juveniles appear with some regularity in false confession cases. So that was in 2005. And then even the Wisconsin Supreme Court said, this is a problem.
Yeah.
So that's why we need the recordings.
Yeah.
Then I quoted the American Bar Association's standards on it, and they echo that point. Quote, official conduct that does not constitute impermissible coercion when employed with non-disabled persons may impair the voluntariness of the statements of persons who are mentally ill or mentally retarded.
Again, that's probably the accepted wording back in the time when this was written.
Yes. And here's the point you mentioned earlier, next paragraph. Against this backdrop of vulnerability, one of the nation's leading police training firms has publicly announced that it uses Brendan's interrogation tapes to train officers nationwide, quote, what not to do, quote, when interrogating juveniles and individuals with intellectual impairments.
Right. Yeah, that's Wicklander Zawalski. So yeah, that's
Yeah. So I also highlighted Saul Kassen's white paper, and you can actually get that online. I know our friend Smokey's been looking for articles, and I would commend him to following that link and getting that paper. The full paper is available, and that is an excellent resource.
By Smokey, he means the Mad Scotsman, folks. Anyways.
Yeah. Okay, so now we're going to the next page, down to the footnotes. They're quoting the Kassen Saul's paper, Enbow and Reed, Criminal Interrogations and Confessions. Using deception or false evidence should be avoided when interrogating a youthful suspect when low social maturity or a suspect with diminished mental capacity. So, that's one of the leading training firms, and they have it in their guidebook. Don't use this. Below that, there's more examples of tragedies with false confessions, juveniles. There are lots of stuff in the footnotes, plenty of heartbreaking stuff. So now we're down to page 10, and I highlighted, this is interesting the way they frame this, as all 7 judges on the Court of Appeals agreed. This is the Seventh Circuit Court of Appeals. Dassey is obviously guessing during the final March 1 interrogation about what happened to Halbach, including when he was trying to describe the act of killing itself. So all 7 judges agreed he was guessing. So it's like, well, how on earth did you end up with this 4-3 decision where he's stuck with a conviction? Well, and they're going to talk about what the tragedy of it is. Listen to this language. Highlight below. Perfectly illustrative of a special education student grasping at straws to describe a murder he never witnessed. This exchange is a red flag for false confession that, again, mimics other known cases. And then, of course, they cite to, if you go to that footnote 50, they are discussing more false confessions of juveniles that And by the way, that discussion is contained in a report by the International Association of Chiefs of Police. That's not a defense bar journal. That's
Right.
not a psychologist journal.
Right.
That's from a very well respected, for sure nationwide. They call themselves international, but that's a very well respected police executive organization in the United States. Next page. I just did this one thing where they noted, the court did, left to his own devices, he couldn't decide whether Halbach's shirt was white or black.
Right.
Then on bottom of page 11, they talk about the Olin's case, why he falsely confessed in a high-profile murder, and he thought he was going home. Who's that sound like? Who thought they could get back to
sixth period
to finish project.
Right. And the truth was, he was looking forward to going out with a girl after school, as well, on top of the fact that he had a project due, but which makes it all the more tragic.
Yeah. So then the next page, this is important, and this kind of winds in with you talking about your control question a lot. The garage bullet substantiated not Brendan's unprompted confession, therefore, but rather the interrogator's own theory, fed to him and adopted by him because of extreme suggestibility on videotape.
Right.
So in terms of logic and analysis, they were arguing, oh, well, we found the bullets and we found this and we found that because of his confession. And they pointed out at every step of the way, including in this petition, that no, they had a theory going in, and they sold it to Brendan, got him to
spit it back.
Right. Somewhat. And they ran from there. Then they mention the bottom of 12, free of his interrogators for the first time, Brendan immediately asked his mother, what happened?
What had happened?
What had happened if he, meaning his uncle, Stephen, admits that I never did nothing? His mother directly asked him, did you? He says, not really. And referring to the interrogators adds, they got to my head.
I've always found that interesting, folks, where he says, what had happened if Stephen, or what had happened if he admits that I never did nothing? Do you understand why Brendan's asking that, folks? Because the interrogators had earlier threatened him, saying that Stephen could say things that could incriminate him. So Brendan's using reverse logic on that. He's kind of reversing that and thinking, well, what if Stephen said I didn't have anything to do with it? And that's why he says that. I think that's interesting because Brendan is at this point trying to figure out how the truth can set him free. And that's what prompts him to ask that question, in my opinion. I always found that interesting.
And so the next page, and we've talked about this both privately and I think in shows, but I know certainly privately, they mention, and in the weeks after his arrest, he also told his mother over recorded jail phone calls when she asked, how did you come up with all of this shit if it ain't true? Does that sound like Barb?
Yeah, yep.
No offense. Anyway, that he had been guessing during the interrogation, just like, quote, I do with my homework, end quote. There's also another quote in that same call. I thought that he said guessing on test, but I may have that convoluted. But in any event, that phone call to me is when Barb, for the first time, and it's weeks after his arrest, Barb for the first time realizes just how much trouble Brendan's in.
Yeah.
And she starts to say, that means we're going to have to prove. And then you could see it was silence, but you could just figure all of a sudden it's dawning on her.
Right.
We're going to have to prove you confessed to all of these terrible things because you thought it would help you, and that
Yeah.
and you could just hear total exasperation in her voice. And that then they put in here, and I thought this was nice. Even after being convicted, when asked what he wanted to tell the judge before being sentenced, Brendan said, "Just that I didn't do it, and I couldn't do nothing like that."
Right.
So at the bottom, here's another good resource I wanted to point out. Bottom of 13, footnote 84. See Making a Murderer, season 1, episode 4. Transcript available online. If y'all have never seen those transcripts before, they're linked. There's a transcript of every show. Unfortunately, they don't break it down by speaker. So it won't say Brendan saying this or Barbara saying this. It just has what everybody's saying. So
just has the words being said.
Yeah.
Whoever they're being said by. Okay, got it.
But if you're familiar with what you're trying to find, you can figure it out. Okay, so I've switched to green on the next page, meaning these were things that I really wanted to get out. And so let's go for another. We'll see how far we get, Erekose, another 10 or 15 minutes, and then see what kind of questions we have. Think that's the best way to go, and then pick up where we left off, or I don't know I can't see the comments, but I don't know how we're doing with time. But we want to go another 15 and then open it up for some questions.
Well, I think if we go the other 15, we'll finish. So yeah, let's do that.
All right. These federal judges' skepticism has long been shared by some Wisconsin judges, including Judge Patrick Willis of Manitowoc County. You all know Patrick Willis's name. He was the Stevens trial judge,
right?
Afterwards, Judge Willis took the extraordinary step of writing and placing in Avery's case file a letter asking any future readers to keep the following in mind when reading Mr. Dassey's statements. Well, yeah, that is an extraordinary step. But what I wanted to point out here, and why I put this in green is very important, is that's because of Jerry Buting. Jerry Buting found an opening in the probation sentencing report that was prepared. The probation officer discussed how horrible and nasty, and put in the sexual assault and put in Brendan's confession. That gave an opening to Jerry to do this long sentencing memo where he went through all of the confessions, so-called, and in detail, and explained how they were utterly coerced and manufactured by the interrogators. He also attached Dr. White's report that he had arranged to get back when they thought Brendan might come in and testify against Stephen. They were prepared for that with Judge White's report. After Stephen's trial, and obviously Brendan didn't come in and testify, they contacted Brendan's trial attorneys and said, look, we've hired and paid for Dr. White. Here's his report. He will come down and testify in Brendan's trial. And he is top notch. And he is. And they said, we've paid for him already. We've already talked to him about it, and you're good to go. But why this is in here is because of Jerry Buting. And read some comments, in the past, and commentary and some theorizing that Jerry Buting, buddy with the state and
Right.
Ken Kratz or the Attorney General's office.
Yeah.
Jerry Buting is a lawyer for people alleged to have committed crime.
Right.
I mean, he is a defense lawyer's defense lawyer.
Right.
It courses through his veins. It courses through the veins of his wife, also a lawyer.
I like this last one here that you highlighted, dude. I just think that that's particularly profound. It's worth underscoring, as Judge Willis did, that the rape portion of Brendan's confession was so unsubstantiated that the state of Wisconsin voluntarily dismissed sexual assault charges against Avery before his trial. So I think that's interesting because, if you think about it, those charges are dropped before trial. I mean, that's and yet to this day, one of the biggest reasons people say, "Oh, well, what about the raping and the there's no proof of it." And I mean, the dropping of those charges is only more, proof of the fact that, even the courts weren't willing to entertain it.
Right. And then, the part I didn't highlight underneath there, but people can go back and read that paragraph in 14. They talk about the legal absurdities that Brendan's the only one who's charged with mutilation of a corpse, that Brendan is the only one charged with convicted of sexual assault.
Right.
When even by his own confession, he's at worst a willing co-participant. It's just legally absurd.
Yeah.
Next page, I got something in orange here.
Yep.
I like the language, and if you'll bear with me, I'll read through this quickly. This outcome is attributable to a yawning gap in confession law that forces the obvious problems with Brendan's confession to the case's legal periphery. Under the increasingly outdated view, this is important.
Yeah.
Under the increasingly outdated view of confession law that prevailed in Brendan's appeals, courts are not required to undertake an analysis of a confession's reliability. Courts are not required to undertake an analysis of a confession's reliability.
Right.
Under this view, even a defendant who definitively proves his confession false is entitled to no constitutional relief from the courts. That's why Brendan is where he is at. And that law needs to change, and we're right. It is going to change, but we're right at that crossroads. And unfortunately for Brendan,
he's one of the ones signaling the change.
Yep.
But he may miss the train.
That's right. So if the Supreme Court of the United States changed that standard and went back to, no, you need to go look back behind the facts of the confession,
right,
that could be what could get Governor Evers over the hump. Let's see, below that, and again, in this case, 4 judges of the en banc Federal Appeals Court found that the state court had not been unreasonable to conclude that Brendan had not been forced to confess. This is they didn't break his will.
Right.
For 3 reasons. They didn't physically abuse him. He had been seated on an upholstered couch, and that they offered him a soda.
Right.
And yet, all of the things that you and others have been talking about, when you break those statements down, those interrogations, we're just going to come out and say it. who shot her in the head. I mean,
Right. Yep.
mattered for naught. And then of the resulting decision, Chief Judge Diane Wood wrote in dissent, Dassey will spend the rest of his life in prison because of the injustice this court has decided to leave unredressed.
Yep.
I think
Powerful
that's kind of
words.
yeah. Then down below, Roman numeral 2, no confidence in the process leading to his conviction. This stuff gets into Kaczynski, which is one of the big things that got me started in all of this way back when a dentist friend of mine had questions, and I've been trying to think of ways to articulate just how bad Kaczynski's behavior was and just how unprecedented. And then this legal team came up with beautiful language. This is the bottom of page 15, last paragraph. In the words of Milwaukee-based magistrate Judge William Duffy, Kaczynski's representation of Brendan amounts to one of the most indefensible instances of attorney misconduct ever seen in this state or indeed around the country. I think that sums it up. Wish I'd said it myself. Next page.
Not to some think he was doing his job.
Oh, good Lord. Kaczynski eventually testified that his purpose in making these statements, this is in the media talking, about all these stupid things that he said, Brendan's remorseful, all these inculpatory statements, was
Right.
get his client's family accustomed to the idea that Brendan was going to plead guilty. We saw that in MAM 1, episode 10, and he gets up there and actually says that, and just unbelievable. So the next thing I've got, I skipped way down because it's just a lot of repeat everybody's familiar with, but I'm going down to Roman numeral 4, page 22. The exercise of clemency in this case, like Brendan Dassey, finds precedent both within Wisconsin and in other states. So this is really, really important. I've been saying for a long, long time that under Wisconsin Constitution, Governor Evers has the power to commute his sentence. Now, I couldn't find one very recent, but I found one fairly recent, a drug conviction, cocaine. It was a state senator's son, and the governor pardoned him. Okay, well, obviously, Brendan doesn't have all those things going for him, but well, again, this legal team, they're so thorough and do such a excellent job of covering all their bases. What they found out is, if you go down to the next page, as detailed in the attached exhibit, and again, I'm going to try and get this for you before Friday. I don't know if Laura or Stephen are around or if they'll even get back to me. At least 39 individuals who had been convicted of murder, manslaughter, or attempted murder have received executive clemency in Wisconsin.
Right.
And nothing to do with whether there's a pardon board, nothing like that at all. You just get it to the governor, get him to read it, and make a decision. Basically what they're saying is most of those 39 are way worse than Brendan when you look at different factors. They weren't juveniles. They didn't have claims of innocence. Doesn't appear any of them had disabilities. Then they also mentioned this other case that's been getting or got a fair amount of notoriety. Virginia governor pardoned an 18-year-old Robert Davis, a high schooler, falsely confessed to arson murder. And then they go through all of the similarities between the two. And I highlighted one. Brendan, they said, I'm just going to come out and ask you who shot her in the head. With this other young man in Virginia, I'm going to bring it out as a question, but I know the answer. did you or did you not stab that woman? Well, guess what that young man ended up telling police that, yeah,
Right.
I stabbed her after getting it wrong 3 or 4 times.
Sure. But when he says things like, but I know the answer, I mean, yeah.
Yeah. That young man,
And
probably.
it's clearly intimidating the kid. I mean,
Yeah.
that's,
Yeah. That young man probably was a little bit higher in his test scores. When Brendan was asked, when he asked, hey, will I be able to get 6th period? No, you're going to be placed under arrest. He asked, is it just for one day? Robert asked, is it going to get me home tonight? After being told no, he added, then why am I lying about all of this to you?
just so I can go home.
Yeah.
Right.
I mean, if these weren't so tragic, it's just humorous to look at it. Fortunately, Robert got justice. I wanted to point out this next part on what it's going to take to get Judge Evers to reconsider. In the following years, a good deal of public attention developed around Robert's case, including after confession experts from both law enforcement and psychological communities explain why Robert's interrogation was likely to produce a false confession.
Just like what's happening now for Brendan.
Yeah. Aired on Dateline. He ended up having to actually serve 13 years in prison. He got a conditional pardon. I don't know what the conditions were. I suspect that he did not have to confess or acknowledge guilt.
Right. It looks like it's the equivalent of a commutation. So that would mean
time served.
Right. Yeah. Right.
And then returned a second petition for an absolute pardon based on actual innocence after a year, which was granted. So my hats off to the former governor of Virginia. Now we're to the last part. Nature of clemency relief sought. So wants a full pardon of all 3 convictions. And he wants a waiver of the rule limiting pardon eligibility to those who have already been released from prison.
Right.
A waiver in previous administrations has been permitted. And then they say, if you want more info on this, let us know and we'll get it to you. That to me suggests they didn't think that was very likely. But they wanted to leave the possibility open. And so they said, if you need more info, let us know and we'll get that to you. If they don't give a full pardon, they want it to be commuted to time served with no remaining supervision time, meaning he wouldn't even come out on parole. He wouldn't have to report to anybody.
Right.
The board has not, to undersigned counsel's knowledge, adopted any rules limiting eligibility for commutations. So they're saying there's no rule saying we can't submit this for the governor's review, so we're submitting it. And so that's why I keep saying they didn't apply to the board under the normal pardon process, which is get out of prison, file the application. If you qualify, your rights get restored. You can vote, maybe get a hunting license, become a cop, whatever. But, that. And then they also added, we would like you to consider, even if you give him time served, we would like you to consider giving him a full pardon for the sexual assault, because that would require sex offender registration. That would be public, and it would put Brendan in grave danger, which tells me there's still a lot of folks in Wisconsin that don't have an open mind about this.
Oh, I know. I remember when Brendan was days away from getting out before, and that's when I had one of my first run-ins with one of the Gilter commenters. I had King Bragg telling me he hoped that Brendan would get shot down like a dog in the street and whatever, like when he got released and stuff. It was pretty horrific. But yeah, there's definitely some people there that are closed-minded.
So, and then they close with, and this is what I'll finish up, ends up with a quote from the great bard. The quality of mercy is not strained. It droppeth at the gentle rain from heaven. Skipping down, again talking about mercy. But mercy is above this sceptered sway. It is enthroned in the hearts of kings. It is an attribute to God himself, that being the power of forgiveness. This is from The Merchant of Venice, Act 4, Scene 1, which, as you all know, is the courtroom scene where Shylock is trying to get literally his pound of flesh, and Portia, who's dressed up as a man and acting like the judge, is trying to tell Shylock that, mercy is probably a better way to go here. Are you sure you won't take money instead of your pound of flesh? But talk about beautiful language. Mercy is in the heart of kings, and it's an attribute to God himself. And earthly power doth then show, like us gods, when mercy seasons justice.
Right.
So that's what I got.
Yep. All right. Finishing up a little Shakespeare there. All right. so all right, folks. Anybody, now that we're done with going through the thing, anybody out there have any questions of anything there while we were going through that you want to ask?
I just put the link in there again. I hope it works. That's to Laura and Steve's legal site. Their clinic. What's next? For Brendan, what's next is really nothing at this point. What's next is another window of opportunity to present another pardon or clemency petition. And as they said in their petition, there's really no legal avenues currently. That could change depending on how things progress with Stephen's case, or they could stay the same. You could have a situation where Stephen ends up getting a new trial, but because of these things are not identical to each other, the two cases could end up where it doesn't benefit Brendan. It would increase the pressure to create this legal absurdity, and I would probably trigger a new time to file an updated petition, but there's nothing really next for Brendan at this point, which was what was so heartbreaking about the form letter that the pardon board sent to Brendan and his lawyers a few days before Christmas. But I did want everybody to see that it's wasn't for lack of effort and professionalism and the petition that was prepared and submitted on Brendan's behalf, and that his entire team is still with him, including his, Wisconsin lawyer Dvorak and his federal appellate counsel, the former Solicitor General of the United States, is still on his team, and they're not giving up, and so that's positive. But it was disappointing that happened.
Right. So, Belinda, the question is, yes, we are, in fact, at the beginning of this video, and I'll say it again now that we're getting towards the end of it, we are currently on Discord in the legal corner, Travis's legal corner over on Discord. We are currently trying to finish up and pull together the final documents to put together that final video. If you are interested in helping with that process, you can go over to Discord to Travis's legal corner and help out. We're basically just trying to gather a few of the exhibits together that are referenced in the appendix of the filing. So that's what we're working on there. It's very close. So yes, it is coming. We were talking about this tonight because Travis was just going through this and making some notes, and he had a pretty burning desire to talk about it, and so here we are. So, but we are very close on the other one, so it is coming. Okay. J Jax asks, what legal remedies can we take when FOIA requests are denied or stalled for weeks, even months?
So FOIA is the federal, and I assume they mean the FOIA equivalent in Wisconsin, and it's all spelled out in their statute. In Texas, it's real simple. I'm not sure what it is in Wisconsin. I can look at that at some point, but unfortunately, the last time I looked at it, was answering some questions about that. You have to appeal it to the circuit court there, and usually the only people that appeal those types of things are movie documentary producers, newspapers, and magazines, because they have a team of lawyers on retainer to fight those battles. They can get convoluted based on what exceptions they're trying to claim that it's a pending investigation, which certainly this isn't pending any more. I wouldn't think, although I think the Wisconsin DOJ has taken that position because of the testing statutes, but I don't know what the law is. But typically, to take action, sometimes in Texas, there's a preliminary administrative process that's really user friendly. It's not too difficult. It goes to an agency that looks at it, makes a determination, and tells the governmental entity, we don't agree with you, produce the documents, or we agree with you, produce the documents. And either side can appeal that to district court. But that's expensive to do.
So Henbury asks, and I think I know the answer to this, but Henbury asks, can the parole board make any findings or determine any facts as a matter of procedure, say in the event of granting clemency to Brendan, that Stephen can introduce to his own matter? And I'm going to answer that by saying, well, no, because this is a political mechanism, right? And it's not a judicial mechanism. As we were talking about, I think a little bit at the beginning of the video, you were talking about how Scott Walker himself dismantled the entire board because he didn't feel that the executive branch of the Wisconsin government had any business getting involved in the judicial branch, right? So I'm thinking they're two different branches. My guess is no. Trav?
Yeah, that's true in the technical sense. First of all, I think I misspoke and called it the parole board at the very beginning. I see in Hembury's question, he says parole board. It's actually the pardon board. Parole board's a different.
Right, pardon, right, yes.
Yeah, but I think that he means pardon board. They wouldn't necessarily make findings of fact like happens in the circuit court, or supposed to happen in the circuit court if they grant an evidentiary hearing, but it's reviewed. And if they went for a commutation, that would have to go to the governor with a recommendation, maybe from the board, that they grant it. it wouldn't necessarily be findings of fact, but it'd have a memo on the top of the file to the governor saying, grant this, see attached, and there'd be a memo as to what they believe is credible, what they believe is the appeal on why the governor should grant it. So to that extent, they would make some what their findings were. They're not legal findings, but they're reported to the governor to get him to help in making his decision. Then the other thing that would be a possibility is that it's a commutation for like time served, which was their alternative request. They can attach condition. They could make it conditioned upon Brendan confessing his guilt. Would that be tragic? Because he's probably never going to do that. Could be conditioned on that he live a certain place for an initial period of time. Can attach all kinds that he stay out of trouble, commit no new offense other than a traffic violation for 3 years, or he goes back in. The governor can attach any conditions that he wants to an offer of either a pardon or a commutation of sentence. Then the inmate, prisoner, Brendan, would get that, and with his counsel, they would determine if that's something that he would be willing to live with or not. But they can attach conditions.
Right. Absolutely. So, all right. Well, let me see here.
Amber says something about somebody wearing a dress. I guess I should have been.
There's some talk about the Masons. I don't know.
The Masons.
Yeah, because the talk about the good old boys club in the area, the Masons possibly being involved. It's a theory that comes around every once in a while.
It's it's pretty simple. Occam's razor. Read about that. Just cut to the heart of the matter. There's two political parties in this country. Two political parties in that state. That state went from red to blue recently in the election of the governor. Elections have consequences. So what needs to be done is people who are eligible to vote in Wisconsin need to register to vote. They need to turn out for local elections, specifically for sheriff and DA in their county. Typically, those are off-year elections, and only 20% show up. Erekose and I did a big turnout the vote in the last election cycle in Wisconsin. It was primarily for who was running for
Supreme Court Justice, right?
Supreme Court Justice. And I doubt it had anything to do. We didn't tell anybody how to vote, what party, anything like that. We just gave them the resources to research
right.
Who they thought would be best for their issues. And 30% of the people turned out for that. I doubt it had anything to do with Erekose or I, but we did have a lot of people from Wisconsin commit that they would turn out for the vote.
A lot of people on Twitter. That got talked up by a lot of people. Tracy Keogh. So it may not have been just us here over on my channel, but there's a lot of people that were involved in trying to make that a big deal. So,
and then we just saw, and I'll dig more into this stuff for more suggestions, but petitions are great. I know there's petition for Brendan now, but 20,000 people from across the U.S. isn't probably going to make too much of a difference to Tony. 20,000 registered voters that signed a petition in Wisconsin online would make a big difference. And I don't know how to effectuate that in Wisconsin. I don't know. A lot of times you can make a lot of headway and form a coalition with the labor unions. They've got a lot of pull in that state, and if you can get them on board and whatnot. But in any event, register to vote wherever you live and turn out for those local elections. Be informed, like all of you are and are trying to be, about criminal justice issues, criminal justice issues dealing with juvenile confessions, the recording of juvenile confessions. That is of paramount importance at this juncture while we're in this lull.
Yeah. Yeah. So, all right, let's see here. We got any other questions here? Let's see.
I'm sorry, Henbury. What's the bone? Is that a pun? He's got a bone to pick with me. People frequently have a bone or two to pick with me.
Let's see. It seems like the teachers union in Wisconsin, if we get them to back Brendan, it might make a difference. That's a fair point. And Evers might pay attention to it.
Well, I think what we need to do is pool some money, purchase a ticket for Millbilly to go to the Packers game and have him hold up that banner in the end zone.
Do you want to join us, Henbury, or do you want us to schedule it for another day? You come on here and pick the bone right now if you want, but we are at an hour and a half almost, so maybe another time would be better. He's got a Brady bone to pick with you, apparently. So,
what did I say about Brady?
He said he's listening to you on 80 More Things, and he has a bone to pick with you for something he's hearing over there. Not what you said here. So, anyways,
No, I know I saw that, but I'm trying to think what I said about Brady over there. I thought I talked about everything generally. Maybe I didn't explain an example or an analogy very clear, and it came off like I was suggesting something wasn't viable or not. But we'll find out and we'll get it answered.
Right. Okay, so let's see if we have any other questions here to go through.
So at this juncture, I was supposed to have a recording from Finn promoting my sweaty balls, but it's too expensive. I can't afford her anymore.
Right? Yeah. Yeah, was it 3 times scale? What was it at? Anyway.
She's over 3 times scale. I know that.
Yeah.
I'll be right back.
Okay. Uh-oh. What's he doing now?
It's right here.
There it is.
That?
A sweaty ball.
It's a sweaty ball. These are double fudge.
Double fudge sweaty balls.
Yeah, and these are the best balls you've ever had.
All right. And on that note, folks, Merry Christmas. Happy New Year. Because it seems like everybody's basically saying goodbye in the chat here. Well, wait. 7 pairs of panties. Are they going? Let's see. Whoops. Are they going to start a PCR for Brendan? Because it hasn't done one. He hasn't done one like Steve. Okay, we talked about that a little bit. 7 pairs. Right now they're not. That could change, but right now they're pursuing this pardon clemency path or road or whatever you want to avenue. But yes, it's still there. It's still something they could attempt and try, and it's still available to Brendan.
I don't see that happening in the near future. There's
Right.
nothing they have to chop on, cling on to. They independently. I think they're going to wait and see what happens with Brendan's post-conviction relief path. Depending on how that goes, it may help Brendan, and he can file a 974.06 motion like Stephen's going through now.
Right.
Or depending on how they rule, it might be super favorable for Stephen, but be of no consequence legally to Brendan because of the differences in the evidence in the two cases.
Right. Right. So, yeah, Brendan's in a less than ideal situation, but he has a lot of people that care about what happens to him, a lot of supporters, and a lot of people out there fighting for him. So, legally right now, the courts in Wisconsin have him kind of pinned, but will it stay that way? Time will tell. But that's about it for this one, folks. If you haven't already, please hit subscribe. Say goodbye to Travis, and Travis, say goodbye to everybody.
Happy New Year. If we go live, we're going to be doing fireworks again out at the ranch. So maybe if you're around, we can do.
Okay. You got good Wi-Fi out at the ranch, right?
Yeah.
All right.
And then we're going to try and get this comprehensive review.
Yep, we're working on it, folks.
And
remember to go if you want to go and try and help gather the documents together that we're trying to get all together for it to make it, perfect, really comprehensive. If you want to help out with that, go over on the Discord, Travis's Legal Corner. That's the room where we're currently trying to do that. So for those that are interested. Alrighty, thank you, everybody. We'll see you. If you haven't already, please hit subscribe.